I'm really delighted to introduce to you all a friend and fabulous attorney, Mr. Eric Rossbach. Eric Rossbach is Vice President and Senior Counsel at the Becket Fund for Religious Liberty. He has been involved in litigating some of the most important religious liberty cases of our time, including Hobby Lobby and the Little Sisters. The Becket Fund represents individuals of faith from all different denominations, which I know is something that Eric is personally proud of. And I'm delighted to invite him here today to discuss in particular a Supreme Court case that was argued yesterday called Espinoza versus Montana. And Eric, first of all, could you just tell us why this case, why Espinoza versus Montana is particularly important?
Yes, and can you hear me okay?
Absolutely.
Okay, wonderful. It's I'm glad we got to talk about this. It's a really important case about the both religious liberty and schools, in particular school choice. And the effects of the case, depending on how the court decides it, could be relatively narrow, but they could also be massive in the sense that there are a number of state provisions around the country, state constitutional provisions called Blaine Amendments that exist in 37 to 40 states, and they ban the use of public funds, state public funds, to for people to use scholarships or things like that at private religious schools. And if those are ruled unconstitutional, which is what we've suggested to the court, then that will work a massive change, I think, in the law of religious liberty in this country. And it would also really enable a lot of school choice ideas and programs that have been held back for decades to go forward.
So that's great. And could you tell us just a little bit about the specific case? I think that one of the petitioners is named Kendra Espinoza, and I believe that she wanted her children to attend public school, or excuse me, to attend private religious school. Why wasn't she able to do that?
Right. So her name's Kendra Espinoza. She lives near Kalispell, Montana. And what happened is the Montana created a scholarship program that gave tax credit to up to $150, so not a whole lot of money, for contributions to scholarships for students to attend private schools of their choice. So essentially, any taxpayer in Montana can get this kind of tax deduction for donating to this basically charitable cause of helping kids that otherwise would not be able to go to get a scholarship and go to one of these private schools.
And so are parents able to choose any school that they want to under the Montana tax scholarship provision?
Well, so the original law that was enacted, yes, they could. Then I would say the bureaucrats got involved. And so first the Montana Department of Revenue passed a rule saying, okay, we'll have this law, but we're not going to allow it to go to religious schools. So we're going to have a rule interpreting this statute that's been duly enacted in Montana to take all the religious schools out. And of course, most of the private schools in Montana do have some religious affiliation.
So now how does all this square with Trinity Lutheran? I know that there was a case a couple of years ago called Trinity Lutheran. It involved a religious preschool in Missouri. And in that case, I believe the court held that you couldn't take a religious entity out of participation in a generally applicable program just because it was religious. But that seems to be what the Montana Department of Revenue did here.
Yes, so what you're talking about with Trinity Lutheran is exactly right. That the court said 7-2, actually, that the Missouri could not exclude a church playground from a recycling program, tire scrap recycling program, solely because of its religious nature. But it was one of these exact same state constitutional provisions that Missouri was relying on, the Missouri Blaine Amendment. And so now we have the exact same situation where but the difference is that it's not tire scraps for a playground. It's about whether they can get an educational scholarship. And so part of the argument is that that's too far away from tire scraps. But
And should that make any legal difference? I'm sorry, I don't see the difference between tire scraps and the tuition help here as a legal matter.
I don't think that there really is one, but lawyers will always try to make a big deal out of any differences they can find between the case they don't like and their own case. So.
Absolutely. Fair enough. So can you tell us, I know you've written for SCOTUS blog, can you tell us a little bit about the history of the Blaine Amendments and why they might be particularly problematic today?
Right. Well, so the Blaine Amendments are not super well known. You may have heard in your middle school history class, American history, about Blaine, James G. Blaine, continental liar from the state of Maine. That was certainly the only thing I knew about him before I became a religious liberty lawyer. But he actually almost got the U.S. Constitution amended to say that no federal or state money could ever go to any religious institution, and they called them sectarian institutions. And at that time, in the 1800s, mid 1870s, that was kind of a code word for Catholics. And so there was a real feeling that we like our schools to be Protestant. So all public schools at that time basically had Protestant religious content. So kids engaged in Bible reading, they were led in prayer, they were instructed in religious precepts, but they were all sort of a broadly Protestant viewpoint in terms of what the content was. So when a lot of Catholic immigrants came from Ireland or from Italy or other places, they said, well, we'd like to do this too. We just want to have, we'd like to use our Bible, not the other Bible, or we'd like to have Catholic prayers, not these other prayers. And there was a sort of backlash to this. They still wanted to keep the Protestant religious statements. So what they did was they said, well, sectarian, that's not sectarian, but Catholic is, or actually Presbyterians and Lutherans were also considered to be sectarian. So you couldn't talk about specifically Lutheran ideas or specifically Presbyterian ideas. So they passed these laws. It didn't get through the Congress to go into the United States Constitution. But then what happened was that the U.S. Congress went around saying, if you want to become a state, you must include one of these provisions in your state constitution. Mm-hmm. And so that's why it exists in about 37 states. Montana was a territory up until the 1880s. And as a condition of entry as a state into the Union, they had to include a Blaine Amendment.
Okay, interesting. So what's sort of the whole theory or the justification for these Blaine Amendments anyway? Because I understand that the federal Constitution in Zellman and in a bunch of different cases has held that it's perfectly permissible for a state, in Ohio in the Zellman case, to offer tuition waivers, tuition assistance to religious schools, so long as it's sort of a neutral program. So why are they allowed to go above and beyond the Establishment Clause, and is that a problem?
Right. So you're absolutely right. Zellman made it clear that the Establishment Clause doesn't prevent this kind of tax scholarship program. It doesn't prevent vouchers, which are not at issue in this case, but are a similar kind of issue. And but then this is kind of the fallback position. The Blaine Amendments are the fallback position for people who don't want religion in public life. And so they weren't really invoking them up at the time that the Establishment Clause was interpreted to say that you couldn't have these programs. But once the Supreme Court in Zellman said vouchers are okay under the Establishment Clause, even if 99% of the kids go to a religious school, once they did that, they started invoking these Blaine Amendments. And so it was a little bit like a landmine from history that's just been sitting there, and then now we're stepping on it.
So, and then in Trinity Lutheran, if I understand correctly, the court said it's okay in theory to have these Blaine Amendments, to have extra Establishment Clause protections, but wait a minute, there's a second provision in the First Amendment, and that's the Free Exercise Clause.
Right. That's exactly right. And so what they've gone from saying is, in the 1970s, they said you can't have this kind of program under the Establishment Clause. And now the Supreme Court is moving towards saying that, you have to treat everyone equally under the Free Exercise Clause, which is the other religion clause in the First Amendment.
So great. So it seems like a good movement for school choice. And I wanted to ask you, from oral argument yesterday, was there anything that was particularly surprising that you saw or read in the transcript there?
There are a lot of really interesting things. So first of all, the Justice Kavanaugh said, this is based in grotesque religious bigotry. Don't you agree? To the lawyer for the state of Montana. And he said, well, there was bigotry in the 1880s, but it's okay because they reenacted the Constitution in 1972 and kind of whitewashed it out of the original intent out. But he agreed on the record that there was grotesque religious bigotry that was motivating the original Blaine Amendments. So that's a pretty remarkable change from what his people have often said in the past about the Blaine Amendments. So that was interesting. It was clear that Justice Kavanaugh was very passionate about this issue. Grotesque religious bigotry is not sort of typical Supreme Court oral argument language. There were some other interesting things that went on. I would say that there's a large discussion about standing at the beginning of the argument. But to me, it seemed like it didn't make a lot of sense to me, because the question is who's harmed here, right? That's the question you always get in a case. And it's clear that the kids who don't get tax scholarships are getting harmed.
It seems like harm to me.
Yeah. So, and ultimately they might not be able to get the education that they would like to get. And sometimes in rural states like Montana, there's not a lot of options. And so if you get told, well, you don't get to go to the school you're trying to go to because we're going to yank this tax scholarship, that's a real harm. So I guess I don't see that going too far. It was interesting, though, that there was a lot more discussion about that than just the merits of the discrimination piece. I would say also there was a good distinction or discussion in the arguments about two different things. One is, can you ever use a Blaine Amendment? So this is something that we've talked about, is that once you have a sort of something that's a little bit like one of these segregation laws in the South, or laws that say atheists can't serve on juries or whatever, that those older laws can't be used today, not just in any context. The state is saying, well, we shut down the whole program. The Montana Supreme Court said we're going to shut down the whole scholarship program, kind of burning down the village to save it, as it were. But that didn't seem to get too much traction at the court. It's something called leveling down.
Sure.
So I thought it was interesting. There was the discussion about the discrimination, and then there was also just the discussion about can you have the discriminatory origins of the Blaine Amendments, but then can you have this distinction between two different, can you just say religious groups are out?
Right.
Can you say secular stuff is okay, but religious stuff is not okay? And I think that was also something that got Justice Kavanaugh in particular was talking quite a lot about, what's the difference? If you say, it's clear, we all agree that if you said Jewish schools can't get anything under this scholarship program, that would not be okay. So why is it okay to say religious schools can't get anything?
Absolutely.
And that they didn't really have a great answer for that.
So that's a great description, and interesting to know about the different justices and which ways they may be leaning. Do you have any predictions for this case?
Well, I never do predictions about Supreme Court votes. I would say, though, given the tenor of the argument yesterday, I think that people who are supportive of religious liberty and school choice can feel relatively confident about the outcome. Again, it could be a narrow decision or it could be a broad decision. In our amicus brief, we urge them to say that all Blaine Amendments are presumptively unconstitutional, but they, usually the Supreme Court proceeds in small steps.
Sure. And if the Supreme Court, they've had Trinity Lutheran, now they have this case, it's clear that a number of justices have concerns about Blaine Amendments, both because of their historical background and also because of the fact that they discriminate because an entity is in fact religious. So if they do, and again, as you said, they likely will not, but if they do take the large leap and say that Blaine Amendments are not consistent with the free exercise clause, what could that mean for school choice?
So for school choice, as I mentioned at the beginning, it could be a massively important issue, because what it would mean is that essentially these kinds of tax scholarship programs or voucher programs, which are a little different, where you get the direct funding from the government, those would essentially be very hard to throw out. And what happens a lot in state legislatures, this is kind of a sneaky thing that happens in the legislative process. Someone will suggest one of these things, and then the legislative council will tell them, oh, you can't do this because it's unconstitutional under our state constitution. So if the Supreme Court comes in and says, no, actually, those kinds of state constitutional provisions, the Blaine Amendments, are not legal under the federal constitution, that argument won't be there anymore. And a lot of state legislators will feel, I think, a little more empowered to experiment with school choice programs.
Well, that'd be great for our schools and students. And then lastly, the last question I wanted to ask you is, I know that this term in particular has been an exciting one for religious liberty litigators such as yourself. Would you be able to tell us just a little summary of a few other cases that Beckett is involved in this term, which is kind of astounding for non-Supreme Court watchers to have several cases in one Supreme Court term is quite unusual. So congratulations.
Yes. Well, thank you. Yeah, no, we're just happy to get one case. So getting two cases in a term is great. We have two cases that have been granted for this term. We have a few more petitions pending. I think that those, at this point, are probably more likely to go into the next term. So starting next October. Sure. But for the ones this term, we have two cases that the court is going to look at. One is the Our Lady of Guadalupe school case out of California, and involves a constitutional doctrine called the ministerial exception. And the basic idea is the government doesn't want to be in the business of quasi-appointing priests, rabbis, or pastors via the employment discrimination laws. So, I can't sue my local synagogue for not hiring me as their rabbi since I'm not Jewish. So that would be, a very simple example of that. The question here, it involves two Catholic school teachers. And the question is, they basically taught religion to their students for a good chunk of the week. They take them to mass, they lead them in prayer multiple times a day. So the question is, do they fall on the ministerial side of the line or not? And the court has said that it's going to decide that by the end of June. And that's going to be a really important case. I was encouraged, actually, that Justice Breyer mentioned that religious education was almost the most important thing that at yesterday's argument, he mentioned that religious education was one of the most important things. So I thought, well, that's good.
Yes, absolutely.
You're about to hear an argument about that.
Absolutely.
And then the second case is more well known, and that's the Little Sisters of the Poor case. So this is their
why are we back here again? Didn't the Supreme Court tell them they should win?
Yes, and it's interesting, that they've been there so many times. They would just much rather continue their ministry of helping the elderly poor, but unfortunately, they keep getting in a situation where governmental entities want to force them to purchase contraceptives and abortifacients, and they don't want to do that. So the reason that the case is back now is that previously the Obama administration had been saying you must provide these contraceptives, etc. That was sent back, as you mentioned, to the lower courts for a deal to be worked out. A deal was worked out, and the Trump administration also passed a rule under the Health and Human Services Department to say that we're going to accommodate religious organizations. It doesn't matter if you're a house of worship, you can also be nuns. So nuns are included this time around.
In religious, yes, that sounds obvious.
It sounds like it ought to be obvious, but for some people it wasn't, unfortunately. And unfortunately, it's still not obvious to the attorney generals of Pennsylvania and New Jersey, and actually also California and Massachusetts and a few other states. And they sued over that rule. And they said, this rule is just horrible. We can't do this. And so that's what happened with that.
So great.
And so we'll see what happens, but this is hopefully third time's the charm.
Absolutely, absolutely. Well, best of luck with those cases, and we are very grateful for your expertise and your work on religious liberty. Thank you so much for joining us.
Thank you, and I'm glad we made it happen.
Absolutely.